In 2012, Mark Zuckerberg paid $1 billion for Instagram. His stated reason in his own email: neutralize the threat. That one sentence is now Exhibit A in one of the largest antitrust trials in American history. In this video, we break down that document, the FTC's three core allegations, and why this case affects billions of people who have never set foot in a courtroom. The FTC's three core allegations: the Instagram acquisition eliminated a nascent competitor. The WhatsApp acquisition neutralized a potential rival before it could challenge Facebook. Meta operated an acquire or bury strategy documented in internal communications. Case timeline: 2020 complaint filed to 2021 federal judge dismissal to 2022. Revised complaint accepted to 2024 to 2025 pretrial proceedings. The market definition battle. FTC defines the market as personal social networking services. Meta argues TikTok and YouTube belong in the same market, which would cut Meta's share below 30%. This definitional fight is the hinge of the entire case. Instagram, the $1 billion threat elimination 2012 context. Instagram had 13 employees and 35 million users. Facebook was approaching 1 billion users but was losing ground on mobile photo sharing, Instagram's core use case. Zuckerberg's internal emails, House Antitrust Subcommittee 2020. Internal communications show an acquire or neutralize competitive strategy. Present as documented evidence, not direct quotation channel Constitution source standard. The FTC's argument: $1 billion was an abnormal price for a 13-person startup. The FTC argues the premium was paid to eliminate competition, not to capture synergy or technology. Meta's counter-argument: Instagram couldn't have scaled independently. Facebook's infrastructure is what took Instagram from 35 million to 2 billion users. WhatsApp. The $19 billion insurance policy 2014. Context: WhatsApp had 450 million users and was growing at roughly 10% per month. It was in direct competition with Facebook Messenger. The $19 billion price. The company had near zero revenue. The price was paid entirely on the basis of future competitive potential, not current financial performance. The FTC's second allegation: Meta acquired WhatsApp to take it out of competition, not to build it. Acquiring a threat is not the same as acquiring a product. The integration argument. The 2021 WhatsApp privacy policy change requiring data sharing with Facebook is framed by the FTC as monopoly extension rather than platform improvement. In the courtroom, who has the stronger case? 2023 to 2025 proceedings, pretrial hearings, discovery phase. What documents did Meta seek to keep sealed, and why does that matter? Meta's primary defense market definition objection. If TikTok and YouTube count as personal social networking, Meta's alleged market share drops significantly below the threshold typically required to prove monopoly. The FTC's strongest evidence: Zuckerberg's own written communications documenting a strategic framework of acquisition as competitive suppression. The judge's signals: the 2021 dismissal wastes on procedural grounds, insufficient market definition data. The 2022 revised complaint was accepted, signaling the court found the updated market evidence credible. If the FTC wins, what actually changes? Scenario 1. Structural breakup. Instagram and Slash or WhatsApp are divested as independent companies. Historical precedent. AT&T's 1984 breakup under Judge Harold Green. Scenario 2. Behavioral remedies. Meta avoids divestiture but accepts mandated data portability, API access for competitors, or algorithmic restrictions, widely considered the more likely outcome. Scenario 3. Consent decree/settlement. Similar to the Microsoft antitrust case closed with regulatory oversight conditions rather than a structural break. What it means for users. If competition increases, what changes in how Instagram's algorithm allocates attention and to whose benefit? If this breakdown is useful, hitting the like button helps the algorithm surface this to more people who want real analysis over opinion. It takes 2 seconds. If you want to follow the full big tech antitrust story, We've got the Apple DOJ case and the Amazon FTC case coming in this same cluster, the same system, different defendants. Subscribe so you don't miss them. So where do you think this ends? FTC win, meta win, or settlement? Drop it in the comments. Next video, the Google ad tech case. Can a court actually force the sale of DoubleClick? Subscribe and we'll walk through the filings together.